Blake Lively and Justin Baldoni. Here is the turn nobody saw coming. A federal judge just sealed Blake's deposition and, get this, called out a move that looked designed to create scandal. That one ruling yanks oxygen away from trial by internet and forces everything back onto evidence that actually counts. Tonight, we connect the receipts. Why a 292-page transcript vanished from public view. How leak allegations lit a PR firefight. And what this says about who really holds leverage as we head toward trial. So who is winning here, and what can they prove? We start with the order. The court struck a 292-page deposition transcript from the public docket and kept it sealed for now. Translation: no fishing expedition for headlines, no drip-feeding out-of-context excerpts, and here is why that matters. Judges do not waste words when a filing looks more like publicity than procedure. The bench notices? In a single stroke, the court slows the PR machine and recenters the case on what is admissible. It also flips the power math, at least for the week, advantaged Lively. But if transparency was the goal, why upload a rough draft instead of waiting? For an approved record, who benefits more from buzz than from rules? Quick rewind, it ends with us blew up the box office in August 2024. Massive opening record run. But rumors were already swirling because Justin skipped most of the press tour and even walked the New York premiere carpet separately. Days later, he brings in crisis PR by December. Everything is on fire. Blake files a complaint, alleging harassment and a retaliatory smear campaign. Justin denies it and fires back with his own legal salvos, including a defamation suit against a major newspaper. More suits follow, names you know get pulled in. A leaked voice note apology surfaces. Meanwhile, a judge warns both sides in early February. Stop litigating in the press or the schedule tightens. Then, in June, Justin's big countersuit is dismissed. Blake trims to emotional distress, claims to streamline her case. All of that sets the board for the moment we are in now, and this is where scandal meets substance. Coverage locked on that word for a reason. Publicly docketing a rough draft of testimony looks less like serving the case and more like feeding a narrative. That is the fault line of the entire saga. The internet rewards spectacle, the courtroom punishes it. From here on, every move gets graded by one test. Does it survive the rules of evidence? Yes or no? Line up the timelines and you can feel the split: press, absence, crisis PR hires, a website for evidence drops, leaks and counter-leaks. On a parallel track, you have dismissals, warnings, protective orders, and now a ceiling. Which story needs headlines and which story needs receipts? Now the leak allegations, and here is where it gets messy. Blake's filings accuse Justin's side of leaking deposition details, including superficial descriptors within minutes. The effect, her team says, is a pre-written story that she is shielded, dramatic, and afraid of her own words. His team disputes that there is any smear campaign. We are not guessing here. We are following filings and timing. Add one more fact. Justin attended Blake's July 31st deposition. Days later, Blake moves to yank the rough transcript from the public docket, calling the upload a stunt to taint the jury pool. For days after that, the judge grants her motion. Why does timing matter? Because once a narrative calcifies online, it sticks. But courts do not grade vibes, they grade proof. The real question is not who looks better, it is who can tie a specific leak to a specific person with something harder than rumor. Did Justin's side push counter receipts to neutralize Blake's claims, or was the timing just convenient? About those counter receipts, months earlier, Justin's counsel released behind-the-scenes clips from set to push back on Blake's account of a particular on-camera moment. And get this, video always feels like truth. You hear joking, you see choreography, you think case closed, but slow down. In a courtroom, context is everything. What is the full cut? Who edited it? What is captured versus what is alleged off-camera? Blake's side says the footage actually supports her, pointing to body language and to the words exchanged. Justin's side says it contradicts her claims. For viewers, this is instinct versus receipts. The screen can sway you in a day. Admissibility is a different hill to climb. If optics can move public opinion, what happens when the judge limits the playing field to authenticated clips, vetted messages, and sworn testimony only? That is exactly what this new order does. It narrows the stage. By striking the rough transcript from public view, the court dials down trial by timeline. Both camps have to recalibrate. Less theater, more substance. Layer in that earlier warning from the bench: stop trying this in the press. That is not etiquette. That is leverage. Because if a filing is seen as publicity over purpose, you open the door to sanctions talk. And sanctions do not just sting reputations. They reshape strategy. They change settlement math. They tighten the funnel on what gets said and by whom, which leads to the next question. If the court probes who filed what and why, whose communications, logs, and email trails get dragged into the light, context still matters. In June, the court dismissed Justin's sweeping countersuit. Even if a narrow slice could be amended later, the headline effect was real. Leverage shifted. Earlier that month, Blake voluntarily dropped to emotional distress claims after a tug-of-war over medical privacy, framing it as streamlining for trial. Put those pieces next to this week's ceiling win, and you start to see a pattern. The bench keeps nudging both sides away from spectacle and toward substance. Draw the two-track timeline. Legal rulings on one side, media hits on the other. Watch how the weight shifts as the court keeps closing the oxygen valve, and ask the obvious follow-up. Between now and jury selection, what are the real stakes? Money, career, optics, or the credibility that decides everything behind the scenes? So what will a jury actually see? With the draft transcript sealed, the focus shifts to evidence that can cross the finish line. Vetted deposition excerpts, authenticated messages, any video that clears the rules. Not rumor, oxygen, receipts with provenance. Also, watch the widening circle. Who else gets pulled into testimony? Who ends up in device forensics? Who shows up on a subpoena? Remember, a leaked apology can set social media on fire, but admissibility is the only flame that counts in court. If both sides pivot to substance, expect fewer anonymous quotes and more careful lawyering. Quiet is not boring here. Quiet is dangerous. It usually means someone is building something real for trial, sanctions, and strategy. Blake's side has floated sanctions tied to publicity tactics. The court has already warned about press side jousting. If the judge bites, penalties could chill theatrics and tilt settlement math overnight. If not, expect a subtler PR chess match. Same players, fewer bullhorns. Either way, the message is clear. Play to the rules, not the crowd. And if neither side blinks, the battlefield becomes motions and lamine, witness lists, and forensic authentication. The practical question becomes, what date is the next real inflection point we should circle? That circle lands on March 9th, 2026. Between now and then, watch 3 Dial's first evidence scope, which clips and communications make the cut. Second, witness gravity. Who gets subpoenaed? Who ducks? Who surprises? Third, gag order energy. Does the court clamp down even tighter if the PR war flares again? The game is shifting from headlines to admissibility, and that favors the side with cleaner, tighter receipts. Also watch whether Justin's team tries to amend anything the judge left open, and whether Blake's team keeps pairing to the strongest core. The next big reveal should not be a leak. It should be a filing. Here is the scoreboard. As of today, reputations are on the line. Careers are under a microscope. There is real legal exposure if the court decides filings crossed into spectacle. Money matters, legal fees, potential damages. But credibility is the currency that sets settlement posture and jury temperature. Next verifiable milestones include any sanctions rulings, subpoenas that widen the witness list, and pretrial fights over what the jury actually hears. And the open questions we will carry forward. Who controls the narrative once the court walls go up? Whose receipts survive the rules of evidence? Follow the filings, not the noise. I will be right here when the next order drops.